That also goes with paragraphs 3 and 4, my lord, because
It's a completely different question.
with regards to any other purpose outside of the Ingonyama Trust Act.
Doesn't all this illustrate that the urgency from your client's perspective, when I say your client, I'm talking about the first applicant, is that it wants the freedom to litigate against the seventh respondent in the Supreme Court of Appeal in circumstances where the seventh respondent doesn't have legal representation. Because it's clear on these papers, it should be clear to everybody, that from his personal stipend, the seventh respondent can't pay lawyers. That's what's urgent in this case. Assuming that's correct, is it legitimate?
My lord, we have not stated that he should not have legal representation.
The effect of your orders is directed at that.
What we have stated, my lord, is that in the event that any payment is made to the seventh respondent, that it be lawful in its nature and that it be condoned by statute.
So you repudiate paragraph 5, which has just got to do with
We do not. No, my lord.
utilization of funds for personal interests, and you've defined personal interests as including legal fees.
The personal interest, so any funds, my lord, which are unlawfully made to the seventh respondent, we do not personalize that to say that it's
You
legal
repudiate
funds in nature.
the proposition that this case is actually about depriving the seventh respondent of legal representation by cutting off his ability to pay legal fees.
No, my lord,
You
we are
do-
not
you
attempting
refute
to
that.
cut that off. This relates to the lawful disbursement of funds.
In your papers you say that the disbursement of funds for litigation like the litigation your client has instituted against the seventh respondent is unlawful because it's personal.
Public funds to litigate. He is entitled to receive public funds in order to litigate on a throne, on the issue of the throne. That's fine. And he's
My lord, it is our submission that we are not attempting to stop any use of, for example, legal funds for legal services, or to stop him from accessing legal services. However, what we are speaking about, my lord, is the lawful disbursement of funds. And for example, with regards to the national legislation that is condoned, and we do not seek any relief in that respect. As with the Ingonyama Trust Act, my lord, that is why we have stated that it be the unlawful disbursement of funds. And similarly, the 8th and 9th respondents have also stated that they don't oppose to the extent that the relief that we're seeking does not extend past the lawful disbursement of funds. And as with the government respondents, and in that respect we have referred to the Premier, is that if there are funds that are allocated, that again, it be lawful in their nature. It be condoned in terms of statute.
The only question is it urgent that that decision be
Indeed
made?
so, my lord, because if one were
about
to
public funds.
go into the question of public funds that are perhaps allocated for this, my lord, and it is not lawful in its nature, then it is urgent. It is prima facie urgent.
Is there a case which says that the unlawful expenditure of public funds, or an interdict against the unlawful expenditure of public funds, is always urgent?
My lord, can I get back to you on that one? Because I would think that there is.
Yes, I've got a funny feeling there might be. Is there anything else you want to say?
I do not, my lord, unless you have any other questions for
No.
me.
Thank you.
Yes, please.
Mr. Bardenhorst, does your team come next? Yes.
Klopper will argue.
Thank you. Thank you, Mr. Klopper.
May I please? My lord, perhaps I need to start off where my learned colleague had started off with the case law that the seventh respondent relies upon on the issue of urgency, and quite correctly referred to footnote 11 in our heads of argument on page 7 thereof, referring to a case, Chopra versus Avalon. My learned colleague had made the submission that this specific case law perhaps finds no application in this particular matter. But the footnote clearly states that the judgment in the Chopra matter relies on a judgment in the matter of Jutan Company Limited versus Legal and Financial Publishing, also referred to in the footnote. That's 1969 judgment. It's in footnote 11 as well. And the relevant portion thereof specifically deals with the remedy or the relief sought in this application, an interdict pendente lite. And if I may take your lordship perhaps just to the relevant portion, because it really sets the basis upon which we argue that delay is, in this particular relief sought, is what caused this application. It's one of the factors not to be urgent. And that your lordship will find on page 445 of that judgment from paragraph A, in the middle of paragraph A, to paragraph E. And it states the following. This was by Van Wyk J, the Honourable Van Wyk J, in Cape Provincial Division. Relief pendente lite is a special remedy. It grants relief between the time of the order and the final determination of the dispute between the parties in order to avoid undue prejudice while proceedings are pending. In view of the long delay that has not been satisfactorily explained and the other points referred to, I'm not prepared to allow the replying affidavits to be filed, and the application must accordingly be refused. This decision also has a bearing on the issue as to whether a court should, in these circumstances, allow the applicant to proceed with an application for an interdict pendente lite, if one bears in mind the long delays for which no explanation has been given. That is, that as far back as December, the applicant had numerous clear cases of copying in his possession according to the letter written by the applicant, that up to now no action has been instituted. It seems that the applicant has erred in selecting this method, namely an application for an interdict pendente lite. Even if it was the appropriate procedure at the time, the applicant has, by reason of the facts stated above, forfeited its rights to this temporary relief. Had it issued summons at the time when the notice of motion proceedings were instituted, the trial could have already taken place. My Lord, my submission in this regard is that the court needs to take note of the fact that this application today is the fifth urgent application, dealing with what I would refer to in essence the main thrust of the applicant's case. In all these applications, and may I add, none of the previous four urgent applications seeking interdictory relief against the seventh respondent, the King, has been successful. In this court, twice, the matter has been struck from the roll on the basis of lack of urgency. The recent one in this court was before your brother Kun J, where he said the matter cannot be urgent. The approach adopted by the applicant in dealing with this issue appears to be that the identification, the recognition and inauguration of the seventh respondent as King of the Zulu Nation is unlawful. That's been the case. It's the subject matter in a previous application dealt in this court before the Honourable Madondo J, where the Supreme Court of Appeal now has put the final nail in the coffin, so to speak, when it denied leave for the applicant to appeal that application, and on the basis that there's no prospect of success. But the main thrust was, it's the purported unlawful identification and inauguration. We submit, my Lord, on behalf of the 7th respondent, that the current position is clearly stated. In the judgment for the review application, which was heard before in Judge Davis in Pretoria, which currently forms the subject matter of an appeal in the Supreme Court of Appeal, the issue of identification was decided upon in favour of the 7th respondent. However, on the remaining inauguration procedural, administrative procedural issues, the review was allowed and set aside. Then that whole issue, on both issues, identification and the setting aside of the inauguration, was then, leave to appeal was then granted, and that matter is currently pending in the Supreme Court of Appeal. On that basis, my Lord, the position, previous position then stands, which means that where we are today, the 7th respondent was duly identified. That comes from the judgment of Mudondo. Secondly, that he was identified, recognized, and then also inaugurated by the President, which as we stand today, the status is that he is the King of the Zulu Nation, and he has to act in that position until a court with competent jurisdiction sets that aside. We're not there, and we now know, my Lord, that in terms of Section 18 of the Superior Courts Act, specifically Section 18 sub 1 and then 3, the only remedy, should that ever be merit for that, is to then approach the Pretoria High Court in terms of the provisions of Section 18 sub 1.
Mr. Klopper, I think what you're addressing me on now goes in the main to paragraph 2.1 of the relief that is sought today. And I think we got to the position with Ms. Mnyati that we should proceed upon the basis that 2.1 is not very strong insofar as urgency is concerned. But if you look at Part B on page 5, in these review proceedings, they're going to seek, in due course, an order setting aside decisions and resolutions of the board, let's call it, to disperse monies for purposes other than advancing the interests of the beneficiaries of the trust. In this case, now today, Part A, paragraph 3, 4, and 5 of the interim relief sought is to try and stop specific types of expenditure not in accordance with the provisions of the Ngunyama Trust Act from occurring pendente lite. Isn't that the position?
Well, my Lord, perhaps that's what remains now after I've heard my learned colleague. But the fact of the matter remains that...
It doesn't, sorry, the point I'm trying to make, it doesn't have anything to do whether or not the 7th respondent is lawfully the king.
Indeed, my Lord.
It's got nothing to do with
Indeed.
that. Yeah.
Perhaps what I submit would need to be the basis upon which one would even consider his position against the accusations which we submit of frivolous and vexatious. It is in fact that he is the reigning king, and as such automatically takes up position as trustee of the Ngunyama Trust, and then may either take up the position as chairperson of the Ngunyama Trust board or may have a nominee. Currently, the position is that he is now also the chairman of the Ngunyama Trust board. And it is indeed so, my Lord, that the Ngunyama Trust board has been appointed for the very reason to take the responsibility of all administrative functions relating to the Ingonyama Trust. In that regard, my Lord, I have to take what my learned colleagues acting for the 8th and 9th respondents have submitted in their answering affidavits to the position insofar as the current position, financial support and the rest. I heard my learned colleague make submissions about the issue of expenditure for legal fees. My learned colleague appearing for the 4th respondent, the Premier, has submitted a rather voluminous and comprehensive explanation on the expenditure, especially for legal funds, and how that is channeled through the Premier's office. Nothing untoward. It is an expense.
No, but that goes to the merits.
Indeed, my Lord,
There are cases, and in this regard, the evidence I'm referred to is that it has to do with the legal fees already incurred by the 7th respondent with Strauss Daly.
Yeah, no.
Their cases, there is unlawful expenditure underway. And it must be stopped now before it gets out of hand. That's effectively it.
I've heard my learned colleague make that submission.
Yeah.
But my Lord, my learned colleague relied on Annexure PM6, the letter that they say, here's the letter, and they rely on the content of this letter for the submissions they made. But what my learned colleague had failed to indicate to your Lordship, perhaps, is the fact that in response to those averments and this letter, the 8th and the 9th respondents in their answering affidavit, and if I can take your Lordship to paragraph 19.
Can I look at the answering affidavit? What's it got to do with the question whether this case was urgent?
Well, that's the basis upon which they say there's this unlawful expenditure through the Ingonyama Trust Board.
No,
But
they
my
say
Lord, I
they, and they
submit
want to
there's no
put.
evidence of that
They want to put
whatsoever. In fact, what has been said in the papers, and I have to just look up the specific paragraph, but it's in the answering affidavits, is that the previous board, not the current board, but the previous board, would appear to have had an arrangement or an agreement to pay in installments certain fees to Strauss Daly, the previous attorneys of record. But the current board, before your Lordship, in this case, inherited that. It is not an urgent issue as we speak. It was something historical that had taken place. That is again being supported, and the payments currently both confirmed by the two officers that take care of the royal family, take care of the king, and also take care of the other officials. They have submitted in affidavit that there's absolutely no irregularity, and this, in essence, if I may summarize it, I'm going to...
But Mr. Popper, you're talking about the merits of this thing. Their cases, there's unlawful expenditure underway. They put up some evidence of one particular item of unlawful expenditure. And they say this must be put a stop to pendente lite.
My Lord,
And in the main review application, they want all the resolutions to make such unlawful expenditure set aside.
My Lord, only submission I can make about that from the 7th respondent side, being only the trustee of the Ingonyama Trust, who in that capacity has not made any payments, cannot make any payments, is the fact that if I read the affidavits of the 8th and the 9th respondents, it is a situation that is dealt with well within the ambit of their current authority and what they have inherited, and there is simply no need for any urgent interference in the administration of those funds. There are set protocols and processes which have been explained in comprehensive fashion as to how they deal with these funds. And the question then is, can one really then say that this is a matter of so much urgency? especially taking into consideration, my Lord, that this matter, the first edition of this application came out as far back as the 3rd of October
Yes,
last year.
yeah, well, I think that perhaps your better argument lies there. You can't argue that it has been established that there is no case, therefore it could never be urgent because there isn't a case. You can't argue that.
That's the point. That's the point.
My Lord,
This could have been done long ago, is what you...
Indeed.
Is you made that
Indeed.
argument.
if there was merit in
Has
it,
has the first applicant disclosed in his papers when he first became aware of the fact that there was illicit expenditure on the part of the Ingonyama Trust, illicit in the sense that it paid the personal expenses of royalty?
my Lord, I stand to be corrected, but I could not pick up a specific explanation and timeline of events as to when this came about, how did they learn of that, and what is the merit and the substance of those allegations. But what I can submit to your Lordship is that this issue came up as far back as the 3rd of October, and by reason of a Rule 30A irregularity notice that was served, that application was then withdrawn. It then again was re-entered into the flow on the 13th of November. And if one now considers the notice of motion and the urgency that my learned colleague proposed, I need to just point out to your Lordship, perhaps on the timelines in the notice of motion, that it says at the bottom of page 6, take notice further that no such notice, if no such notice of intention to oppose be given, the application will be made by this Honourable Court for an order in terms of the notice of motion on 13 February. There was no date given for the hearing. It was says if it's not opposed, then that will be on an unopposed basis. Hence, again, a long delay of what is expected of the respondents who had now filed opposing notices of intention to oppose. And this matter was just dragging on ad infinitum until eventually the Judge President then gave us timelines, and even those timelines were not adhered to by the applicant. I submit, my Lord, that on the basis of the existence of this alleged unlawful expenditure, there's simply not enough evidence submitted by the applicants to suggest that it is something that came about recently and that needs urgent attention. I submit, my Lord, it still remains a vague submission. And my Lord, if there's no merit in the submission or in the allegation of unlawful expenditure, then it follows there can't be any urgency.
No, but you can't argue that. It's a question of the cart and the horse. You got them the wrong way around.
My Lord, our submission is that there is simply no unlawful expenditure whatsoever. We want to make that submission because on the evidence,
Mr. Klopp, if you want to make that submission, you must explain to me exactly why, as a matter of logic, it's relevant to the question of urgency, because that's all we're debating.
my Lord, I submit that the applicant's case on that issue of unlawful expenditure is based on speculation. It's based on media reports. That's hearsay evidence, inadmissible. There's no factual evidence to indicate any unlawful expenditure on the part of the seventh respondent.
No, on the part of the Ingonyama Trust.
Ingonyama Trust Board, but I don't appear for them, but I submit, when one looks at the position of the seventh respondent as king, trustee of the Ingonyama Trust, and now chairperson of the board, that obviously came after the fact that he was also, by necessity, had to take up the position of chairperson of the board for the interim. But that is his position as the reigning king, and that is his prerogative, and he's merely exercising that prerogative. But On the seventh respondent, there's simply no evidence to suggest with any certainty that there's unlawful expenditure on the part of the seventh respondent.
But he's, according to the founding papers, he signed a letter in which he purported to say that the trust would pay his legal expenses, and he purported to do so as trustee. And the fact that we know he's got no power to do that is neither here nor there. That worried the applicants. They said that sort of thing has to stop.
Well, my Lord, I submit there's a difference in a letter under the signature of His Majesty the King on his letterhead indicating that the trust would be making that payment. In the absence of any detail, one cannot establish on what basis did he make that, that he signed that letter and indicated that the trust would be making payment. Number two, there's also no evidence that that payment in accordance to that letter has in fact been made. Those are the speculation that I am referring to, because there's simply no evidence that that has even taken place, or that they, knowing the legislative procedures for expenditure and authorizing expenditure, we now know that His Majesty the King was not in that position. He was, in fact, at that point in time, not even the chairperson of the Ingonyama Trust. It was still taken up by a nominee. So there's simply no evidence that the seventh respondent had in fact incurred, lawfully or unlawfully in any way, on behalf of the Ingonyama Trust Board, such an expenditure, and in fact made those payments. That, my Lord, I submit, is pure speculation. What we now know, and what is before your Lordship in this application, is a comprehensive explanation from the 8th and the 9th respondent, the Ingonyama Trust Board, and also the Premier, as to when funds are allocated specifically for legal fees, who authorizes those funds, where's the budget for those funds, and who in fact makes those payments for those funds. Now, on that basis, my Lord, that has always been, I will not say common knowledge, but I would say it was always available to the applicant to determine those facts, because it was all there. That's
the
how it's been
applicant
done.
asked for the facts to be determined in respect of the one case it was aware of, or one of the cases it was aware of, and he got no response.
My Lord, that is what I'm submitting. The 8th and 9th respondent says, we never received that letter. That's why it's never responded to.
Yes,
But then they proceed to explain the position.
yes,
and
but
again,
we'll only get to their position on the merits. Is there anything else you want to say about urgency?
My Lord, I just ask indulgence just to get instructions. My Lord, those are my submissions
Thank you, Mr.
relating to urgency. We submit this application is not urgent.
Thank you.
As the court please.
Mr. Dixon.
Lord, I do have some additional arguments to make. We are relying on form and substance. Form first, and form and substance sometimes overlap. Form first. Rule 612A provides the court with a discretion to allow someone to, as the Lord said, jump the queue. And we've referred to the case in our heads of argument of Commissioner SARS versus Hawker Air Services, which is a Supreme Court of Appeal decision relating to this very matter. How do you jump the queue? The method of jumping the queue is contained in Rule 612B, which, just as a reminder, reads as follows. In every affidavit filed in support of any application under paragraph A of this sub-rule, the applicant must set forth explicitly the circumstances which it avers render the matter urgent, and the reasons why the applicant claims that the applicant could not be afforded substantial redress at a hearing in due course. Now, just dealing with that, at page 237, the 8th and 9th respondents say that this is not urgent and they haven't complied. And if my Lord looks at the founding affidavit, there is nothing like it. Must set forth explicitly the circumstances which it is averred render the matter urgent, and the reasons why. That is not in their affidavits, and we invite the applicant's representatives to point out to my Lord if we're wrong. Secondly, there was no certificate of urgency. That is this court's directive number 10, and it states that a certificate of urgency is required. It also states that it's not a mere formality, and in fact the cases of this division set out the importance of a certificate of urgency, and especially in relation to accountability of the legal practitioners involved. And I can give my Lord one example of that. I'm sorry, it's not in the heads, and it's unreported. But if I could just give it to you, it's the judgment of Mr. Justice Lopes in Square Root Logistics versus the Commissioner SARS.
Got the Safley reference.
Pardon?
Do you have the Safley reference?
No, I've just got the, yes, it is the Safley reference, 2022 ZA KZDHC at 11, and it's in paragraph 9, where it is stressed that it's not a formality, and it bears on the responsibility and the accountability of counsel. But that's in our directives, and there was no certificate of urgency whatsoever. But just to get back to our heads of argument, our heads of argument in the introduction have a timeline. And if I could direct you to those, my Lord, I don't know whether my Lord has them handy. There's so much to look at.
Where in the heads?
It's in introduction, first page. There's a timeline. And it involves the false start. And we make a point of that. There was a false start in this application where an almost identical application, and for reasons known only to itself, I know they did explain themselves, but for reasons that only they can explain, they filed an urgent application, and these are the dates in the introduction paragraph. On the 3rd of October 2023, they launched an urgent application which was set down for the 21st of November 2023. And before the 21st of November 2023, they then filed a notice of withdrawal on the 26th of October 2023. So that was like about 3 weeks after they had launched it. So they lost 3 weeks. If one is regarding this matter as urgent and you've got a timeline and you see the time disappearing, 3 weeks were lost in bringing the false start. And then this application followed. It was issued on the 13th of November. That's another 3 weeks. It was set down for the 26th of April 2024 on the basis that if it was not opposed, it would be heard. Well, in fact, everybody gathered at court, and that was the day that we ended up going to see the Judge President about directions and so on.
That was in February.
In February. On the, oh yes, the 13th, I'm sorry, I've made a mistake. That goes back to the notice of motion. It was the date on the notice of motion, which was the 13th of February 2024. That was the date that we all met at court. And then it was set down for the 26th of April. And the Lord heard that strike-off application on the 26th of April. So there was significant time lost. Now the question is, where do you start the clock running? And we have been through the affidavit filed by the applicants, their founding affidavit, to see where they were warned that this matter is a matter of urgency and what it's about. What is urgent? What do we want to stop? And what we find is that there are events in May 2023, those are on page 39. There was also the appointment of the new board, which may have given rise to some
Sorry,
urgent...
just making a note of this. May 2023.
May 2023, it's been struck out, but that's the date that we can find. May 2023 on page 39. In paragraph 61. They started reading about things that disturbed them.
Yeah.
It's been struck out, but that's where we start the clock, with respect to them. May 2023. Then the new board was appointed on the 5th of December 2022, and between pages 56 and 59 you have correspondence from December 2022 to January 2023, largely concerning the new board. Now that may have given rise to certain amount of consternation, which may have even ended up saying that we've got a reasonable apprehension that our rights are prejudiced, and pending a hearing we need interim relief. So if that's what they were complaining about and that's what worried them and gave rise to their reasonable apprehension, we go back to December, January 2023.
But Mr. Dixon, none of the relief sought urgently would have to do with really the
it's part
existence
B.
of the new board.
I'm just giving the Lord the timeline that they're relying on.
Yeah, but that's for part B.
Yes.
This issue arises in part B only.
Well, Lord,
What was
answer.
urgent is the question urgency arises only in respect to part.
Well, that's what I was going to get to, my Lord. There is none. There's nothing. There's nothing that they can be warned about. I'm giving my Lord everything that they've said, and I'm giving my Lord the dates. But there's nothing. There's no other, apart from the fact that they made a whole lot of scandalous allegations which have been struck out. There's nothing, no single act, no single date that's given in their affidavit which gives them the reasonable apprehension to come rushing to court and to justify jumping the queue. There's nothing in the affidavit, and they don't specify the reasons for the urgency at all. In fact, I've already made the point that it was the 8th and 9th respondent who said in their affidavit at page 237 that it's not urgent, and they haven't qualified to be urgent. They haven't said why it's urgent. And there's another point that we wish to make, Lord. I know this is mainly to do with the merits, but if you are wanting to interdict the board on the basis of a letter that the King wrote, you must not misunderstand his role in the 8th and 9th respondent. In fact, the 8th and 9th respondent are one person. It's the Ingonyama Trust. It's a corporate body, not a trust. And we've set all that out in our heads of argument. And Lord, they also Now, in our affidavits from page 211 onwards, we have analysed the act under which the corporate body is established. And if one looks at the PFMA, if you look at their regulations, they are one body. They have an accounting officer, which is the board. And the King is, with respect, a figurehead in the Ingonyama Trust, which, as I've already said, is not a trust, but it needs to be repeated. One has to keep on repeating that the Ingonyama Trust is not a trust, it's a corporate body. So if they came to court on the basis that the King had written a letter and he's the trustee of a trust and we want to stop him doing what he says he's going to do, it's a complete mistake. And it leads to failure to make an urgent case against the 8th and 9th respondent. I suppose that's the point that we wish to make. So that's the substance of it, but I've already addressed the form. They fail on form completely. Thank you.
Sorry, one point does sort of affect you.
Beg pardon?
One point does sort of affect you. It seems that the evidence they rely on now, that is to say the applicants, really has to do with the firm Strauss Daly.
With what?
With the firm Strauss Daly.
Yes, no,
Yes.
and that's something that is part of the merits.
You've concluded a contract.
Yes. We confirmed a contract which had been concluded already by the previous chairperson. It was at the time, and it's all explained in the affidavit, but the point I wish to make about that is that if the urgent application was brought to stop any further payments to Strauss Daly, then one would have had to have brought an application under Part B to set aside the contract on the basis of legality. I'm just thinking aloud. They would have had to set it aside on the basis of legality, and they would have had to join Strauss Daly. Strauss Daly have not been mentioned in the founding papers. So they clearly weren't coming to court to stop payments to Strauss Daly, because if they had wanted to, they would have had to join Strauss Daly. So that came out in the wash. It was the 8th and 9th respondent who candidly said, we've found ourselves in this jam created by the last chairperson who made an undertaking, and we had to decide whether or not we reneged on it or kept with it. Well, they decided to keep it. And that may have created a right in the applicant's hands to bring urgent relief. But they don't even get to it. They don't mention it, and they don't join the right parties. So that's not what it's all about.
So you're saying if the question of stopping Strauss Daly receiving monies from the Ngonyama Trust is the issue, it's not one, is the issue which is urgent. It's not one of which I can take notice because Strauss Daly have never been joined.
No, that's absolutely right, Lord. That's absolutely right. And not only that, they just don't make a case about that particular undertaking or contractual arrangement. That only comes out in the 8th and 9th respondent's affidavit. So because the 8th and 9th respondent have candidly said, we've got this problem, this is how we resolved it, you can't then say, well, that's what our urgent case is about, because it's not mentioned.
Thank you, Mr. Any reply?
Look, I will take the reply, which should be fairly short, because my Leonard Junior dealt
We haven't
comprehensively with our
taken the
case.
short adjournment.
I beg your pardon.
We haven't taken the short adjournment. While
No,
we
we haven't.
started late, the staff have been working from much earlier.
Or is that Oh, that's fine.
We're already half an hour past.
Yes.
Should we not take the short adjournment?
That's fine.
Right, we'll resume in 15 minutes. Thank you, Ras.
Sure.
Bye.
Ja, ons kan net koste kry vir two counts. Ja. Dismissed with costs. So, and that will be the cost of two counsel because there's two counsel every.
Ons vra spesifiek vir two counsel.
Het jy gekyk na die antwoorde verklaring nou?
Ja.
Ja, okay, well.
That's
the way it is. That's the way it is.
Also sê dat the prosecutor at their leisure.
Ja.
Want ek was reg om te sê dat daar's geen datum, daar's geen aanduiding wanneer ek hulle hierdie
Nee,
inligting
waar.
wil kunnen doen. Daar is dit.
Hy is nog geïrriteerd oor ons bietjie met te veel numeriete.
Ander is baie moeilik om nie
Nee, baie moeilik in elk
want
geval.
jy weet hulle verwys na 'n brief.
Dis
Einde
sy
minute.
ja,
Nou,
so
concerns me a little bit from the form perspective. It's true we have not filed certificate of agency, but we would ask the court to direct that we file that certificate of agency for the very reasons that he says it's necessary. We're not running away from being held liable or for the accountability that is necessary. That is served by that particular certificate of agency. So if the court would indulge us to file that certificate of agency retrospectively, so that we cure that formality, which my learned friend, for the first time I hear that's the reason why it is. So it was very educative to hear him say that formality serves that particular purpose. And if it does, as an officer of the court, I have to ask the court to give me the opportunity to file that certificate of agency, so that if there is any liability that attaches to that, then I'm held liable for it.
I think the liability you had in mind was whether counsel or attorneys should be paying the costs wasted by the fact that
well, if that is what it requires, then I can't run away from it. If that is what it requires, then of course we're simply asking that in the exercise of your discretion, and I can't imagine that a formal defect like that would torpedo a meritorious application. Yeah. And it would be within your wide discretion to condone that kind of non-compliance, or even direct that the certificate be filed retrospectively, so that there should be the compliance with that requirement.
Right.
So I can't run away from that. We don't have it.
Yeah.
We had it in the previous application, yes, but we just omitted to do it in the second application. The second thing that is very important, Your Lordship raised the issue of a contract, which I think we need to just deal with quite firmly, because...
Sorry, can we just stay with form for a moment?
Oh, okay.
The other thing, which is both form and substance, raised by Mr. Dixon, is that you are supposed to make very clear statements in your founding affidavit justifying, in this case at least, jumping the queue.
Yes. So there are two...
And he says it's just not there.
No, then he's probably not been reading the affidavit that we've done, because if he had, he would have seen that there are two issues that relate to his particular clients. First one being whether or not they are lawfully constituted as a board. We contend that the third respondent has acted unlawfully and has not established them lawfully. If we're correct, especially in relation to our Part B, that the board has not been established lawfully, then there is ongoing threat that is continuous, that this board, which is not lawfully constituted, continues to take decisions that are very critical to the sustenance of the kingdom, and that's a significant factual basis on which the agency is established. The ongoing threat that an unlawfully constituted board continues to make decisions that are not that ultimately become unlawful. Understand the issue that we can in Part B get the remedy for an unlawfully constituted. But if we are right for Part A, that this board, as we believe we are, has not been lawfully established by the state respondent, we then are entitled to an order that, to an agent approach of the an agent resolution of that particular aspect, so that we limit.
You haven't asked the board to stop its activities, presumably because you know no court's ever going to do that. What you've asked for is that it shouldn't pay any money to the seventh respondent.
No, but that is also important from the first perspective, from the first point I raised. If they are unlawfully constituted, they shouldn't be doing that anyway. That's what we say.
But they shouldn't be doing anything at all. If they're not lawfully the board.
No, yes, they shouldn't be doing anything at all.
Yeah, but you can't stop them because they have been appointed.
I can't stop them because...
You can't get a court to stop them performing their functions because they have been appointed. You need to win Part B.
Yes, but...
Yeah. But now in the interim, and that's only interim relief that's urgent.
Yes, that's what we're seeking.
Yeah. Now, all you've asked is that effectively all you've asked is that the board should not pay anything to the seventh respondent.
Yes, because
The rest they can carry on doing, despite the fact that they're not really the board.
if that one aspect flags the lawfulness point, we're still good with that. We would still be good with that one point. The fact that we've not spread wide enough to say they shouldn't be doing anything at all doesn't negate the potency of the fact that on this one aspect that we've raised, that they are paying legal fees of the seventh respondent without any lawful authority.
Your founding papers merely establish that they had paid, and you fear they still will pay, one firm of attorneys for legal fees already incurred. That's all your founding papers reveal.
Yes.
And you didn't join that.
No, but that's where I was going. Because our focus is the conduct of the board. It is the conduct of the board. And the question one must ask is, has the board identified a lawful basis on which to make these payments? And if the answer is no, that's the end of it.
Well,
We
it's
don't
not
have
the
to
end of
join.
it.
We don't have to join Strauss Daly to make that point, because the board operates in terms of law. And if they cannot point us to a legal basis for making these payments, we don't have to be saying to Strauss Daly, "You are an interested party in this."
So I don't understand you. Are you saying that your case was brought upon the basis that the board, without discussing anything with Strauss Daly, without reaching any agreement with Strauss Daly, was simply paying Strauss Daly a whole lot of money?
No. What I'm saying, my lord, is that the board itself acknowledges the fact that in fact, they do say in page 224, in paragraph 56, that it is unclear at the time how the previous board or chairperson could bind the trust for debts of Ingonyama which did not relate to any of the expenses permitted in the disbursement policy of the trust. What I'm saying, there's already, from the board's perspective itself, an anxious consideration of what legal authority they have to make these disbursements and these payments. On the issue of the fact that there is an agreement which my learned friend says we haven't sought to review and set aside that agreement. The argument that I'm submitting with respect, my lord, is that for my learned friend to demand that kind of approach, he must himself, or the board must himself say, the legal basis on which we are able to do this, to assume this particular debt, is A, B, C, and D. If we're wrong on the legal basis, then of course we're wrong. But they themselves do not believe that they're correct.
Mr. Masoko, please, you're not answering the question I'm putting to you. The
Sorry, maybe I don't understand.
The only identified and payment on the part of the trust, which you have branded unlawful because it serves the personal interests of the seventh respondent, is the Strauss Daly payment. In your founding papers, I can see nothing else. When I look at the founding papers, where your urgency must be established, I can't read them upon the basis that I can assume that the board is paying Strauss Daly without there being any relationship, essentially contractual, between the board and Strauss Daly with regard to such payments. If this court grants an interdict saying you can't pay Strauss Daly, prima facie on your papers, that's going to have a bad effect on Strauss Daly.
No.
Surely they should have been joined.
No, but we've not limited the conduct of the board merely to the payment of Strauss Daly. We've identified that as an example of the board's unlawful conduct that is clear. But we've said two things. The first one is that the board itself its constitution is suspect. That's the first issue. And
That's not what I'm interested in.
I don't know which answer you want, my lord, but I'm trying to give you an answer that relates to the question you're asking, which is that we are not limiting our attack on the board merely on the basis that they are paying the Strauss daily fees. It would be an unfair limitation of our case, because that's not the case we make out in the papers. The case we make out in the papers relates to and in the interim order, we are entitled to ask, bearing in mind that there is evidence we've established that the board is in fact making an unlawful payment, or has made an unlawful payment to the seventh respondent's law firm to cover the legal costs of the respondent, and any other payments that they make, because we don't know what other payments they've made. And Part B will disclose that. Part B will give us a picture of the scope of the conduct that the board the board's conduct relates to. Because once we will have a Rule 53 record, which will set out in detail what has been happening in terms of the monies that the board has been dispersing. We may amend our papers for purposes of Part B. We may amend our relief for purposes of Part B. For Part A, all that we're showing is that even the attitude of the board itself, the attitude of the board is, yes, we don't quibble with you around the issue of payment that is not authorized, because we don't intend to do that anyway. But we've pointed out one aspect, the one aspect that keeps telling us that the board is continuing to make undertakings or make payments to the seventh respondent in relation to the fees. And this
That's
is
not in your founding papers. That's mere speculation. Your founding papers put up evidence that the board is. We've put it to them that information has come to hand that you are paying Strauss daily. We know those are fees that are already earned. And will you please explain yourself? Because you've got no authority to do that. And you get no answer to the letter. That's the evidence you put up. And I accept that you can speculate that there might be other things there. But there is no evidence of it.
No. There's a. Lord, perhaps let me just take your lordship to what has been happening. I will take your lordship to page starts from page 258. And of course, it would have been easier if the undertaking that was sought, that no further fees were going to be paid, was given. We say to them, here is what we know, make an undertaking that you will not continue making these fees. We get no response from them. But from what they have given us now, it's clear that on page 258, there is.
But this wasn't available to justify urgency.
No.
This comes
so
afterwards.
It was, but it was. It seemed like it's like we put a bait by flagging the unlawful conduct of the. We put a prima facie case, and what they did is they completed our story, because they now put up at least evidence in their papers that shows that our concerns about the conduct of the board are prima facie justified. We were justified in coming to court to ask for an urgent interdict, because if we don't do that, most of the things are not done publicly.
Yes, but Mr. Masuku, you must understand that I get completely bewildered.
I'm surprised why you are, but
your order says you can carry on paying personal expenses of the king as long as they were authorized by the old board. That's the implication of the order you ask for. And this transaction is signed by Mr. Ngwenya, the one that starts at page 258.
Sorry, my lord, you say our order, you're referring to our notice of motion?
Yes, the urgent orders that you're asking me to make. Paragraph 3. They can't disburse money from the Ngonyama Trust for the personal benefit of the seventh respondent, save for funds authorized by duly constituted authority prior to the appointment of the respondents.
Yes, but I think the operative words there, my lord, would be duly constituted authority.
That's a reference to the old board.
No. Oh. Yes,
Yeah.
that's correct. Yes,
Yeah.
because
So, and now it's the old board that authorized these payments.
yes, but we say
So where are we going with this?
yes. But my lord, that doesn't answer the agency question.
Well, it's
What it answers. Sorry, my lord. Perhaps
it's the urgency question has to be decided looking at what your case is, and your case is in your founding papers. And you've asked for an order which says it's all right. Making payments is all right as long as the old board said it was.
No, that's an attenuated way of looking at our order. Our order specifically says the 7th to the 20th respondents in their respective capacities are interdicted and restrained from using, dispersing, or in any manner allocating or paying out to whomsoever any funds from Ngonyama Trust for the personal benefit of the 7th responding. I understand that further on we say pending the refiling of the review application to be brought within 30 days in which the financial decisions and administration of those funds by the trustee and the board is challenged, save for those funds authorized by duly constituted authority prior to the appointment of the respondent whose authority and appointment is being challenged in this application.
Yeah.
The first part is significant. The first part of that order was significant. I can understand the difficulty you have with the second part, but that
Well, the
for an
second
interim
part
order,
qualifies the first part.
no, it doesn't qualify the first part. It stands on its own,
Well, you may say so.
and it is so with respect, because we are not we are looking at part A.
That's
We're
what's
looking
got to
at
be.
part A.
That's what's got to be urgent.
Yes, and we believe that we've established the agency. We say with respect, my lord, there is an ongoing threat of an unlawfully constituted board making decisions that will impact on the functioning of the trust, of the lawfulness of the decisions they make. That threat is ongoing because the board, as we believe, prima facie established, the board is not properly constituted. But secondly, we say that there is absolutely no basis lawful basis for the board to continue making financial payments to the 7 respondents in relation to legal fees. They are not they don't have the legal authority to do that. But they say they are now in an agreement to take over a resolution of the previous board in order to pay. But let's test that. Because I just said, referred your lordship to page 258, where Mr. Ngwenya writes and says, we confirm that we received a detailed statement of account, bill of costs and text pertaining to His Majesty, Royal Family. His Majesty is the sole trustee of Ngonyama Trust. Our intervention to the extent necessary, especially in this instance, is to protect the image of the royal institution and the trust. Matters like the present one are not ordinarily budgeted for. However, in the circumstances, we hereby undertake to raise And the undertaking here is not to pay. The undertaking is to raise and collect the necessary funds to settle your account as presented. We know that there is no resolution in respect of this. This was a letter written by the chairperson of the board, but there is no independent board resolution saying that this is going to happen. But the letter itself says we are simply undertaking to raise and collect the necessary funds. They are not undertaking to use trust funds to pay for those expenses. And then if one looks at the next paragraph, the next annexure, which is 260, again, Mr. Ngwenya writes, but he's writing to the trust board, to Ms. Pitout.
Yeah.
And he says, I refer to the subject matter above. You will recall a few months ago, August 2022 to be exact, His Majesty directed me to assist him in settling his outstanding debts from his allowance as a trustee. Now, this is the most important thing, my lord, that one has to looking at this letter. The first one is that the writer says, His Majesty directed me to assist him. So this board then assumes that it is actually something that the board ought to carry. But Mr. Ngwenya says, directed me to assist him in settling these outstanding debts from the allowance as a trustee. For the record, there are funds due to him in terms of the disbursement policy. In terms of thereof, 5% of the trust BK income is allocated to him. Secondly, rental from Tanda properties is set aside for him. I know we have made some payments towards settling some of these debts. In this regard, I need a reconciled statement. And then he talks about the account of trust daily and all that. What now we have is this current board saying, we have an ongoing obligation to honor this. It's not a resolution of the previous board.
Well, these letters do not evidence a resolution of the previous board, but why are we looking at this?
No, because your lordship asked me the question, and persistently asked me the question, and almost limited the order that we seek to a single point against the Strauss Daily. And I'm trying to show here, with reference to these paragraphs, that the conduct of the board is of concern. Because the board's answer to this question is no, we are continuing to pay, and we've paid 1 million. We've undertaken to pay some more money based on the conduct of the previous board. But if we're correct that there was no board resolution on that, it impugns that particular decision that the board is now taking.
Well, if you're going to impugn that as a decision, then why is Strauss Daly not a party to this?
No, because it has nothing to do with the conduct of Strauss Daly. It has everything to do with the conduct
of... Got to do with the rights of Strauss Daly, Mr.
No,
Masood,
no, with respect, what the aim, it's the board. The Strauss Daly does not have any legal base on which to take its decisions. In other words, they don't have a law then under which they sit and say, well, this is how we take, this law authorizes to take a decision. The board operates in accordance with the law and must operate within that prison.
Yeah.
If the board is not taking a correct decision because it does not comply with the law, that is the conduct we impugn.
Yeah.
It is not necessary for us to join Strauss Daly in order to impugn an unlawful conduct. It really doesn't that's not difficult to understand. I mean, our main aim is, here is a public entity, statutory body that deals with public funds, and we are saying that the disbursement of public funds of that particular board, the decision to disperse public funds, has to have a lawful basis. If there is no lawful basis, it doesn't matter that the recipient of that money is not joined.
Mr. Masuku, that, without thinking it through clearly and applying time to it, the proposition that the court may decide that ultimately in the case is probably correct. But before it makes that decision, it should hear the affected parties. And you're saying Strauss Daly is not an affected party. It's not an interested party. It has no right to be heard on the question as to whether the contract it concluded with the board was one within the ambit of the board's lawful authority.
There's one important factor in that summary. Where is the contract that we are referred to as having been concluded between the board and Strauss Daly?
It appears
There
to
isn't,
be.
and maybe it will arise under the Rule 53 record. We don't know.
Oh, maybe it's just an oral agreement. Who knows? I
No,
mean,
but
the
it-
evidence
because
is there
maybe-
that this was the arrangement made.
No, but that doesn't elevate it to the contract, the kind of contract that your lordship.
It does, Mr. Masuku. An agreement,
no.
contract, it doesn't matter what word you use. It's all the same thing.
No, my lord. When a public entity like the board, and my lord, you are at liberty to stop me from making further submissions.
I'm
Because
sorry.
if I'm irritating you, then I'm
No,
quite
no,
happy
no,
to.
no.
If you can't take it, then of course you are entitled to then say, "So I've had it," and we sit
no,
down.
no,
and
no. I'm
we
going to let
go
you
on with
carry
it.
on, Mr. Masuku. Come
Yes,
on.
because I do. It is a very difficult, my lord, to present a case where the remarks demonstrate that you're hitting against the wall, and I'm senior enough to know that I'm not making any sense from the response of the judge. So I don't want to waste your time.
Mr. Masuku, forget about the cameras.
It's not the cameras I'm worried about.
Look,
I'm worried about
I'm worried about the fact that the only evidence that you put up in your founding papers has to do with the Strauss Daly deal. Can we just call it that? Won't use the word contract, we won't use the word agreement. And the fact that if that is viable as justifying urgency, why is Strauss Daly not here to defend its rights under that deal?
No, because what we are attacking is the lawfulness of the board in making that decision to pay. And I've shown your lordship that there is no board resolution on which the board can actually say, we are assuming this particular agreement. We're referred to letters of the chairperson of the board that on their own do not. No, my lord, I'm a bit disturbed by the comment that I must forget about TV, about the cameras.
Leave that, Mr. Masuku, please. I'm
It's
making
not-
a note
it's
of
not
your
fair.
submission here.
not
Can you
fair.
finish your submission?
Yes.
You
I'll
said the
finish my
lawfulness
submission,
of
but
the
I must-
board in making that deal is
Yeah.
what?
But I need an environment to make those submissions that is fair.
Is there something wrong with the environment, Mr.
No, because you are saying that I must forget the cameras.
I'm sorry, I should not have said that.
Thank you, madam. So, in a sense, what I'm really asking your lordship to look at it, to look at this case, is to look at this board, which is a statutory body, and to ask the question: can this board, a statutory body, assume a debt that was purportedly a debt owed, accepted by the previous board,
Unlawfully.
unlawfully? Can they accept that? But even if I were to say, when in the submission there is that firstly there is no board that accepted the payment for legal fees. We've shown the letters that demonstrate no board resolution that has been adopted in respect of payment of these legal fees. But I'm saying, for purposes of Part B, my lord, for purposes of Part B, when we get the Rule 53 record, there may well be a number of things that come up in that report that shows how the board came to the conclusion that there was a board resolution to pay for these fees which they needed to take on and to enter into some agreement with Strauss Daly to pay. And if in Part B that comes up, then of course we have our options. We can amend our notice of motion. We can to the extent necessary, we could even join the Strauss Daly. For purposes of this particular interdict relief, your lordship ought to concern himself with one aspect. Does the board have authority to assume this debt, to assume responsibility for this debt? I think that is very important. Well,
that's a very important issue on the merits.
Yes, and I'm saying for the purposes of the interdict itself, if we say on the if there is a prima facie case that has been made right now, which I believe we have, that the board's conduct, even in its own papers, demonstrate that they're not acting within the law in respect of making these payments, then of course we're entitled to an interdict. We're entitled to an interdict. What happens in future when we get the Rule 50 record that gives us a better picture of what's in there, then of course I think we would be entitled to then deal with the record as it demonstrates, as it gives us a bigger picture. And in that record, my lord, what may well be, what we may come across, are other payments which we have not flagged, which could inform how we amend our notice of motion for Part B and how we redo our supplementary affidavit that we are entitled to make in those circumstances. So we would submit with respect that there is that question which looms, and it's an ongoing threat that if not stopped, then of course the board will continue acting as it does. Will continue acting and making the payments that they've undertaken to make. And if they don't have the lawful authority and they're told that this is a flag transaction, we have to look at it for Part B. Because prima facie you don't have authority to make this payment, then of course that we are entitled to get.
Mr. Masluku, to what extent are the answering papers delivered by the various respondents relevant to the question I've got to decide as to whether this case actually had the urgent status that would have been claimed if you'd filed your certificate at the right time? To what extent can it make any difference, or does it make any difference?
Well, perhaps it does, because you would obviously have to look at the answering affidavit to see whether their answer ought to be given the advantage of the that famous dispute resolution case. What was case? Plus connivance. Whether you can go that route. But what we're saying is, if you look at the answering affidavit, it confirms our prima facie view that there is unlawful actions taking place, the unlawful payments that are being made, especially in relation to the 7 respondents' legal fees. Prima facie they do, because they themselves say, in the paragraph I've referred to your lordship to, we don't know what happened here. So in a way, what we are really saying with respect, my lord, is that the case taken from what we say about the lawfulness of the board's conduct and what the board says prima facie makes out our case for agency, but also makes our case for the relief we seek. Because with respect, if one looks at the board's position is we will bite the decision, but to the extent that we're not prevented from making lawful payments, well, okay. So in a way, they do accept that if we can flag one payment they've made that is not consistent with their powers, then of course we should be entitled to approach the court with agency. Particularly in circumstances where we wrote to them and we said, please give us an undertaking that you won't be making these payments, and they just simply ignored us. We'd be entitled to say we have no assurance that the board will reflect on their powers and make lawful payment decisions in respect of the trustee. My learned friend for the 7th respondent attempted to make a big issue about the fact that there are cases, urgent matters which were brought by the applicant, which were dismissed. With respect, they have brought a counter application of vexatious litigation. They flagged that issue a lot in that application. It has nothing to do with agency. Doesn't assist with agency at all. But what I think is important from...
Sorry, can I just make a note? to use a classic case, what you're saying is because we've messed it up before, it doesn't mean we're messing it up this time.
Yes.
Okay.
Thank you, my lord. And the thing is, I say, pending the big case in the Supreme Court of Appeal, pending that outcome of that case, which challenges the identification, the lawfulness of the identification and the recognition of the seventh respondent, they cannot seriously be suggesting that the board or the premier would be entitled to pay fees, to pay for the legal fees of
For that
seventh
case.
respondent. Yes, even for that, for cases that they cite. For example, they've taken all the interdictory decisions, applications that were launched by the applicants, and they've said they've all been lost, but they're all defended by the seventh respondent. There were costs obviously incurred in those cases, and we say the attitude that pending the outcome of the Supreme Court of Appeal decision, which challenges the lawfulness of the identification and recognition process involving the seventh respondent, the board or the premier is not entitled to make fees, has no authority to make payment to support the litigation of the seventh respondent.
Yeah. Well, I'll be asking you about that on the merits, assuming we go to the merits. I don't know that it has anything to do with urgency.
Yes, but just to close that part, you will understand, my lord, that the seventh respondent's position, which is contested in the SCA decision, in the SCA application for leave to appeal, is not only of interest to the seventh respondent alone. They are siblings of the seventh respondent who are interested in the position. The uncles we're talking about there, they are interested in the decision. What is the legal basis for the government or the board to fund the special interests in the kingship of the seventh respondent, not everybody else? There isn't. So that would be the. I suppose that goes to the merits of the case. My lord would submit that the agency is necessary in order to prevent ongoing threats that public funds will be used either by the premier or by the board in order to continue funding litigation on behalf of the seventh respondent. And really, at the end of the case, that would be the approach that we take on the issue of agency. So, my lord, I would urge that you uphold the agency and you direct that the matter goes further. But finally, your discretion, my lord. Your discretion on urgent matters is very important, and one has to look at whether there are justiciable disputes that have been raised by the parties that are worth of a judicial outcome. And it's important here because we are talking about public funds that are being used in order to fortify a position that is heavily contested by at least the applicants. And we would submit that is necessary for the court to exercise that discretion, wide as it is, to give the applicants or all the parties some justice insofar as they contend there are issues that the law can resolve that are raised in these particular applications. I know those would be our submission.
Thank you, Mr. Musa.
Thank you.
It's 10 to 1. Can we take the long adjournment now and resume at 10 to 2, 10 minutes early, in other words? Will that be all right? So we don't lose any more time. The court will rise. In saying that, I acknowledge, therefore, that there are cogent arguments against the order or the decision that I have come to. I've also warned myself against taking into account the proposition that it is eminently practical that this matter be disposed of now. And I do not take that into account in reaching my decision. My decision is that this case should be allowed to proceed from now, occupying the privileged position it does on the role of this court. I've heard no argument on whether any separate costs order may rest on the outcome of the challenge to the urgency of the case. To the extent that there may, or a separate cost order is justified, I reserve that question. Ms. Masuku.
My Lord, there were interlocutory, points in limine which our learned friends wanted to raise. My understanding is that we deal with them as we deal with every other aspect. So
Yes.
I will run and deal with the in limine points while I deal with the merits themselves.
Yeah.
So, Lord, I will deal with the issue of locus standi, the locus standi challenge of the applicants. Mainly because if that fails, then of course this application fails too. So the way I want to develop the case is to firstly deal with the locus standi, as I indicated, and then look at the relief that we're now looking at, which is no longer paragraph 2.2. We abandoned paragraph 2.2. And really because the issues that we identified there are issues that cannot be interdicted. You can't interdict an event that has taken place. So on reflection, that those orders are not orders we persist with. That was conveyed to our learned friends for the 7th respondent. And then we'll deal with, I'll deal with the issue of the case we have against the 3rd respondent, is the Minister of Agriculture, the Minister who is responsible for appointing members of the board. And that's really to establish the point that in our allegations against her in relation to whether the board members have lawfully been appointed, she has given no answer to those particular allegations. Prima facie, the case that there is a legal question on the validity of the appointment of board members is prima facie in our favor. If one looks at the fact that when we have said that the 3rd respondent has not lawfully appointed them, in these proceedings she has just chosen to file an affidavit and not deal squarely with those particular aspects. So we say at a prima facie level, there is a case to be made for Part B, and Part B will obviously firm up the way we look at the conduct of the 3rd respondent, who is the Minister of Agriculture.
What interim relief do you seek against the 3rd?
No, we don't seek any relief against.
So there was no need for her to answer until your papers are all in on Part B.
Yes, but what we say, the allegations we make about the appointment, unlawful appointment of board members, our allegations that ought to have been answered at this stage. Because in the absence of an answer to those allegations, in the detail that we've presented them, then of course we have at least made a prima facie case for the point we make that at this point our relief the relief that we seek in relation to the board is competent. Then I will deal with the issues relating to the powers of the board and whether we've made out a case for the orders we seek against the board and the Premier. And I will deal with both the board and the Premier because they are, the point we make in relation to both of them is that we cannot locate a power in terms of which they could isolate, in the case of the Premier, 14 million for the payment of fees in the Premier's budget, or it is as a project in the Premier's budget, and in relation to the board, the questions that we debated earlier on relating to whether they could in fact make undertakings to pay for the legal fees of the seventh respondent. To the extent necessary, I will deal with lis pendens, but that point really can be disposed maybe in a sentence. But I'll try and elucidate so that whoever deals with it on that side of the podium deals with it on the basis that we've said something about the fact that there is no pending case before any court that raises the kind of questions that we've raised in relation to the board's conduct, in relation to the Premier's conduct, and in relation to the rest of the relief, really, except that the issues that we've abandoned could notionally have fallen under the lis pendens point. But the point about lis pendens is that there is no pending litigation. So the crisp question in this application for Part A, as we thought about it, my lord, is that the Ingonyama Trust Board and the Premier have no legal authority to provide legal cover for the seventh respondent. And maybe it's helpful to go straight to the board itself to see what, and as I've said about the issue relating to the board, there are two issues that relate to it. Firstly, it's what we say is they are the prima facie view that we take that they are lawfully constituted, or they are lawfully appointed. And the second one, which is that they've taken decisions that are outside the remit of their statutory statutory powers in relation to the payment of the fees of the first respondent. So in the sequence that I said I was going to follow, let me deal then with the issue of the local standing of the applicants. We have, in the founding papers, in the founding affidavit, my lord, set out who these applicants are. And for the moment, accepting that there is one affidavit where there is no confirmatory, we accept that there may be consequences. We did say that one applicant, the last applicant, was in the hospital. I'm not sure whether
He's the fourth applicant.
The fourth applicant, yes.
Isn't the position that the fourth applicant is simply not an applicant?
I beg your pardon?
Is the position not that the fourth applicant is in fact not an applicant? He hasn't signed an affidavit.
Well, that's to the extent that obviously he's not an applicant in that sense that he's not filed a confirmatory affidavit, but the only reason he's not filed a confirmatory affidavit with respect is that he's not well. And we've not been able to reach him, and he went there after the...
I'm sure there's an explanation, yes. But this is a case in which the promise is made that the applicants will identify themselves. We're now running the case, and one of them hasn't identified himself. as a party to these proceedings. It makes no difference to your case.
Let me readily accept.
Put a
Madam.
line through it
Yeah.
and say he unfortunately is not here.
Yes, no. So I'll accept that the fourth respondent is not an applicant, but the remaining applicants are in fact applicants. It's not really understood why our learned friends would challenge the local standing of the first, second,
Third and fifth.
third, and fifth respondents. In the founding affidavit, in paragraph 20, on page 23, this is who they are, and this is how they define themselves. The first applicant in paragraph 20 says, I'm the first applicant in this application, and then the application pending before the South Gauteng High Court Division. I'm the blood brother to the late King Zwelithini kaBhekuzulu, together with the second to fifth applicants. I'm a direct descendant of known and revered kings of the Zulu kingdom and a son of the late King Nyangayezizwe Cyprian Bhekuzulu, kaSolomon kaDinuzulu, kaCetshwayo kaMpande, kaSenzangakhona kaJama. Since the demise of the late king, our brother, His Majesty, I'm the eldest surviving member of the ruling family, of the Zulu royal family. Until I discharge my duty to identify and install a new king for AmaZulu kingdom in accordance with customary practice and law, I remain responsible for the affairs of the Zulu royal family. And that's contested, I understand that. They don't believe that he has got that role. But what they cannot deny is that he is a brother to the late king. In the Zulu customary law, he would ordinarily be involved in the identification of a king. He's contesting that the identification was in accordance with the law, and that he has an interest, an ongoing interest, in the affairs that implicate the seventh respondent and the board, and how the seventh respondent is supported through the public funds that appear to be supporting him.
Well, those who continue to challenge Dr. Standa must speak for themselves. But is the inquiry not whether he has locus standi to claim the interdicts that are claimed today? What have they got to do with him?
Yes. Firstly, so the standing that we claim is based on his status in the Zulu family, because Ingonyama Trust, as your Lordship knows, is a trust that is established for the benefit of the Zulu kingdom.
No. It's not what the Act says.
In terms of the KwaZulu-Natal Ingonyama Trust Act,
Yeah.
my Lord.
Sorry, I'm just trying to find it. Give me a moment. Got it. I understood that it's established for the benefit of the people, I think, mentioned in section 2. Of the members of the tribes and communities as contemplated in the now repealed Act, referred to in the second column.
Sorry, my Lord, where are you reading from?
Subsection 2.2 of the Act.
The trust shall, in a manner not inconsistent with the provisions of the Act, be administered for the benefit. Yes, yes, but the applicants would fall under that group.
A member of the communities.
Yes, would fall under that.
I take it belongs to one of these. I mean, the schedule goes on and on.
But I'm not sure, my Lord, whether you take the issue with the fact that the trust was established for the benefit, I know I'm being, in a way, just being really broad, was established for the benefit and material welfare and social well-being of the members of the tribes and communities as contemplated in the KwaZulu Amakosi and Isiphakamiso Act, referred to in the second column. That the trust is established for the benefit of that group of persons in the schedule, and the applicants would fall under the schedule. If one looks at under Nongoma, Usutu.
Yeah, no, I contradicted your statement, because if you use the shorthand Zulu Kingdom
It's no.
for these communities, then we're implying that there's something special that attaches to either the king or the royal family as a result of this act. And that seems to be hotly disputed in this case.
Yes, no, that's correct. So we say that the interest they have in the way in which the board conducts its affairs in relation to the single asset and the resources of the Ngonyama Trust are self-evident. They don't have to be. And your lordship, having dealt with the other Ngonyama Trust matter, you'd have seen the remoteness of the applicants in that particular case. It was an NGO that brought the application, and it challenged the lease agreements that had been signed between Ngonyama Trust and the members that were certain members would appear under the schedule.
Yeah.
And there was no difficulty in appreciating that the extent of their interest in the manner in which the assets are dealt with is demonstrably there, and it would be quite difficult to understand how the the late king's brother and sister would have no interest in how the land of which the trust is established over would have no interest in how that is managed or handled. We would say that they also would have an interest in that based on, as we say in our affidavit, the sections of the Constitution that give them that right. We refer here to Section 38. In paragraph 4 on page 15, we say that I bring this application in the public interest and of the Zulu people. And here it's used quite broadly. It's not really the identification of the specific members that are in the schedule.
A question arises in regard to that claim. Is there not constitutional court authority which says not anybody can claim title under those sections, subsections of Section 38 of the Constitution? You have to be the right person.
Yes, and this
and
is.
And can the person who's saying effectively, please tell these people not to pay my opponent's costs in the litigation I am in with them, can he possibly be the right person?
Absolutely.
Well, he's got a personal interest in it, which obviously clouds his judgment. It must do.
Invariably, that's what happens when you litigate for a particular outcome.
Yes, but then you can't litigate in the name of the people, if we can just put it broadly, under Section 38, if you're the wrong person to do it.
No, so that's where it's important to understand how they've defined themselves as members of the ruling family of the Zulu royal family, who are by custom enjoined to identify an heir to the throne. And in the context where that identification process is still a subject of litigation, they remain with an interest that simply goes beyond just the identification process only.
But the first applicant was involved in the case in which my then brother Madondo gave a judgment against the first applicant. Or was he
yes,
not
no,
involved?
he was certainly involved in that particular
Yeah,
case.
that's right. Yeah, sorry, there's a lot for me to absorb in a short time in this case, so I'll get some of the facts wrong.
Yes.
And you can correct me.
So
And it's been decided against him, and the Supreme Court of Appeal has refused leave to appeal. So what's
No,
he
that's-
doing saying that what he does in this case about the seventh respondent?
it's an error to see the denial of a leave to appeal in the Supreme Court as a statement on his standing to bring this particular application. Because in the Supreme Court of Appeal, my lord, the application was really narrowed down to a single issue. The issue of whether or not the court in the Madondo judgment, the court in the case in which your brother Madondo was presiding, the issue there that they took to the Supreme Court of Appeal was whether he should not have recused himself, given the fact that he had played some role in the family of the royal family at the time. So the applicant confined his appeal only to that point.
Oh,
It had nothing to do with any other issue that my learned friends are talking about. They were separate appeals. So his was a supportive role, because there were applicants brought by the queen and the princesses that challenged various aspects of the late king's will.
Yeah.
But the Madondo judgment speaks for itself. I mean,
yeah, but you must correct me if I've got this wrong. Before Madondo, the issue as to the identification of the seventh respondent,
yes.
as to whether it was lawfully done or properly done, was one he had to decide.
He
Is that
decided
correct?
it was not one in which my client was particularly.
But was your client a litigant in that?
Yes, he was a litigant in that,
Right,
in that
okay.
case, but it was decided in that case. Yes.
Yeah. And Madondo, I can't remember what position he held at that time. Madondo J made a decision that, in fact, the identification was correct. In Pretoria, Davis J said, I'm not going to go against what Madondo said, so I'm going to accept that the identification was correct. But he then decided that the recognition was not done correctly.
Yes.
Now, both of those are now before the Supreme Court of Appeal.
Yes.
No. But as between your first applicant, I don't know about the other applicants, but the first applicant, and for that, and the seventh respondent, we can just confine it there for a moment. The decision as to the identification of the seventh respondent is res judicata.
No,
Is it not?
it's not. Absolutely not.
Why not?
Because even when Judge Davis granted the res judicata point, he granted leave to the applicants to challenge that particular finding.
Yes, I
of res
know he
judicata.
did.
It's not res judicata to the extent that leave to appeal on that aspect was granted, and it's a matter that is pending before the Supreme Court of Appeal.
But leave to appeal was sought against the judgment of Madondo J, was it?
Not on the question of identification with respect.
No, wasn't it?
No, not
Oh, right. I thought it was.
Not by our client. I hear I hear my learned friends talk about it as if I drafted the papers. To be honest, I'm not putting that as evidence on the bar from the bar. But I know exactly what the case was there. It was really about whether or not Judge Madondo was correct in refusing to recuse himself. That they confined themselves to that one point.
Okay, so he said, I was right, he refused leave to appeal, and the Supreme Court of Appeal also refused leave to appeal on that
Yes.
one point.
Yes.
Okay, thank you.
But it had nothing to do with the identification. But the identification issue is very much alive in the Supreme Court of Appeal, and it will be determined as we go further on it. So the res judicata point doesn't help the applicants, because the matter is absolutely pending before the Supreme Court of Appeal But the applicants are clearly, and I think it must be also clear that it's not just the first applicant who has an interest in this process. It is the applicants we've identified that are interested in ensuring that the resources of the Ingonyama Trust are properly managed, and they're not used in a way that is prejudicial to their own ability to perform their own functions. So your Lordship says, well, you know, they are litigating against the seventh respondent, and because they are litigating against the seventh respondent, they have an interest that's unique from the public interest. But they are not mutually exclusive. I mean, you can have a personal interest that influences impacts on the public interest. For example, there are many issues. By custom, we are responsible for identifying an heir that will, if we're given that responsibility, will identify the seventh respondent, but we have to do it by custom. And if we've done it for the benefit of the public. We've not done it for ourselves. It's really a responsibility, a cultural responsibility that vests in us, but it's vests in us for the Zulu Kingdom.
But what does this case have to do with the identification of the seventh respondent as king?
No, because we're trying to establish the local standing of their locus to bring this application in terms of which they are saying that the functioning of the board, which impacts on how the resources of the board are managed, invariably impacts on the seventh respondent who's king as a trustee. If the board is mismanaging the primary resource of the trust, which is the land and its resources, then of course the king gets impacted on it.
The king gets?
The king can get impacted by that. For example, when the board says they are going to pay for, I'm giving this an example, my lord. I'm not saying that as a fact. That is what has happened. But let's assume that the board says we want to get a jet for the king using the resources of the king. It would be nice to have a jet for the seventh respondent. I mean, the king must fly in a jet. But I'm saying if the board were to say that, even if the seventh respondent were to be happy with it, the clients who I act for would be concerned with that kind of conduct. Because ultimately what happens is that the image of the throne is affected by the unlawful actions of the board. They look at this and they say, but what are the public resources being used to do? And why is the king accepting these kind of gifts? And I'm saying, in the interim where the applicants consider themselves to be responsible for ensuring that the king is identified by them, they have the standing to challenge an aspect of the kingship that impacts on, sorry, an aspect of the board's conduct that impacts on the seventh respondent as king. Great deal, my lord.
For the purpose of that argument, you're accepting that he is the king.
Beg your pardon, my lord.
For the purpose of this argument, right now,
Yes.
the one you're dealing with now, you accept, for the purpose of the argument, that the seventh respondent is the king.
Yes, we accept that he's a king. Part of the reason why we abandoned 2.2.
Yeah.
And we've not asked that the court does not, because we have abandoned those orders, we accept that he's the king. But we're saying that as king, in circumstances where there is still ongoing legal uncertainty, we call it uncertainty, because the Supreme Court of Appeal must still pronounce on whether the identification process was lawfully done and whether the recognition itself was lawfully done. If in the event the Supreme Court of Appeal says it wasn't, and of course we're back at these applicants. These are the very applicants that must look at the matter. In the event that the Supreme Court of Appeal reverses both the identification and the recognition, the matter must come back to the family. And this seventh respondent, doesn't matter how much he feels about this, the applicants, would accept unequivocally that these are members of the royal family who are responsible with the task of identifying a new king.
Isn't that the subject of a denial, perhaps even a bald denial by the seventh respondent in his papers?
Is the subject of
A denial.
yes, but for present purposes, my lord, we as you correctly put, these applicants put it maybe, I'm not sure whether this is colloquial, but they grudgingly accept that he's king, because their main issue is, in law he's been recognized as king. We are challenging that the process is ongoing. But while the process is ongoing, are we powerless to deal with legal aspects that arise that impacts on the status of the king as a symbol of the Zulu kingdom? Where unlawful payments are made to the king, it becomes a problem. So notionally you could get someone wanting to reverse payments made to the king and asking for those payments to be paid directly by him. And that's not a position that you want to put a king in. So you want people who are engaging with the king to be absolutely meticulous in how they relate to the king. And that's why we are saying to the board, do not put the king in a position where these things may come back to affect the throne as of the Zulu kingdom.
But Mr. Masuku, lending a bit of humour to this, isn't the clearest solution to this is that you must stop suing him, then he won't need any legal fees.
No, but then I accept that's supposed to be what they're saying. You must. That's why they're calling us. They're wanting in order that we're declared vexatious litigants. But the truth of the matter is that unless that process is dealt with and it goes away, there will be instances where different members of the royal family could notionally come to court at any time and challenge an aspect of the board's conduct that impacts on the king. There is as I said earlier on, where, for example, the other siblings of the king who are interested in the position of kingship find out that his fees are being paid by the state, the premier, or that the board is actually paying for his legal fees. Would they be entitled to say to the board or the premier, but why have you isolated this one particular respondent and not paying for us if we were to litigate in the same for the same orders that the seventh respondent would be litigating. This issue, my lord, of legitimacy of the appointment and identification process is regarded by the applicants as absolutely sacrosanct. It is the kind of responsibility they regard as very, very important to the very identity of who becomes king. They will not lightly renege on it, because
this issue is not before me.
no, but it is an issue that is being the submission I am making, and the connection I seek to make with that particular aspect, my lord, is that when you are dealing with local standing, you have to look at what the interest of these applicants are in relation to the seventh respondent and all the other responsibilities that relate to the seventh respondent. For example, if the seventh respondent as king was chairperson of the board and basically endorsed a unlawful act by the board, who would say that any of members of the royal family, any one of the members of the royal family would be entitled to challenge it, because it has something to do with a very important resource of the throne of the Zulu kingdom.
Can you hang on just 1 second, please, Roma? My bench book is upstairs. Bench book. It's probably in my chambers. Sorry, Mr. Sue.
So, my lord, thank you, my lord. And so if we've dealt with the issue of locus standing in our supplementary heads on paragraph 60, and you would have seen, my lord, there that we deal with what connects the applicants to the what connects the applicants to this particular case. We say in paragraph 62 that these are, firstly, even the seventh respondent himself accepts, although is not excited about it as much as we are about identifying ourselves. He says the first applicant is a half brother of his father, and of course we take issue with this half brother issue because if he accepts that he's a brother to his father, then he must just accept that he's a brother to his father, his uncle, and not try and devalue the status of his uncle by calling him a half brother. And we do mention the fact that he's a surviving member of the ruling family, of the Zulu royal family in Lugapusha. Now, of course, that issue is still an issue that appears to be contested about what ruling family is and all that. But what gives the applicant standing to meddle, let's put it that way, to meddle in the issues that pertain to how the seventh respondent is maintained is really the fact that they are custodians, they are members of the ruling family who in custom would be ordinarily responsible for identifying the heir to the kingdom. So they don't, in order to get standing to challenge the conduct of the board or to challenge the conduct of the premier
Or the president.
or the president, one needs not be, in the case of the board, one needs not to be be a member of the board, member of the public. And even if you were to reduce the applicant's status to being just members of the public, they would be entitled to know how the board dispenses its resources towards the maintenance of the seventh respondent. And I say the maintenance on a critical aspect that relates to whether his identification as king was lawful or not. And we say that the applicants are entitled to bring this application on behalf of Ubukosi, which is the kingship of the kingdom of AmaZulu. And I accept entirely that if that aspect triggers the joinder issue of AmaKosi, then of course we have to deal with that aspect. But from the point of view of standing, all that the applicants are saying is that in our status as members of the royal family, we bring this application on behalf of AmaKosi, or Ubukosi, Bawazu, which was represented by the kingships of the various kings within the kingdom. Partly because they are the beneficiaries of the trust, and the board decisions invariably impact on this particular on this Ubukosi in a real way. And of course we come in, as I've said, in the public interest of the Zulu people under Section 38C and D. And your Lordship says, well, but isn't there a constitutional court authority that those provisions should not just be used by anybody? And there is. The court is not. The court is not not dealt with the limitations of claiming standing based on those particular provisions. But in this aspect, my lord, I do no more than just refer to your own judgment, which the Ngonyama Trust case in which individual members of society and NGOs were allowed to challenge the board and how it had dealt with the issue
The point I'm asking really has to do with the first applicant personally.
No,
And I don't know whether the other applicants have participated in, for instance, the case that was in Pretoria and is now going to the SCA. Were
Yes,
they
yeah.
involved in this
yes,
as
we were
well?
involved in it.
Well, that means all these applicants have got a personal interest which has nothing to do with the standing they are claiming, in seeing to it that the litigant they're trying to beat in the Supreme Court of Appeal doesn't have lawyers.
No,
Are they the right people?
no, but they would be the right people, because as I said, firstly, they are standing to bring an application to challenge the lawfulness of the identification process and the recognition process. It's not personal. That standing is not personal. It's not for their personal
Yes, I know.
benefit.
But you see, KSAC, in the case you're referring to, has absolutely no personal interest in the outcome of the case.
Yes.
In this case, it's different. Whether or not the king receives funding for his costs from any of the parties you seek to interdict against providing such funding is a material advantage or disadvantage, to win or lose, to these particular applicants. So they don't come before court saying, I'm here for communal reasons. Unfortunately, they're here also for personal reasons.
Yes.
It's
So
inescapable. And as I understand the cases, you can't be the public benefactor if you are in such a position in relation to the case.
No, but you've got to look at their interest, my lord, not as a personal interest. The fact that they are coming in as members of the royal family, their main argument being that custom identifies them for a specific role in the identification of an heir, does not reduce that to a personal interest.
That I accept. Their personal position
Yes.
as members of the royal family, yes, that's in fact a personal. It falls under 38A. I don't have the provision in front of me, but the moment they start claiming to represent the kingdom or all Zulu people or the community or anything like that, are they the right people?
No, but let's take it a little further, my lord, because if let's assume they're successful in the Supreme Court of Appeal, and the identification and the recognition processes are set aside,
Yeah,
and the matter is returned to the royal family,
yeah.
right? They're not performing that function for their individual benefit. They're performing for the kingdom. The identification of an heir, my lord, is not not a matter of personal interest. It's a matter for the kingdom.
All right. So the beneficiaries of the outcome they seek will be the community.
Yes, because then they provide the community with a king who has been identified in accordance with the custom that the community accepts is binding on them.
If money being spent by the Ingonyama Trust is the further spending of money by the Ingonyama Trust on legal costs is interdicted here. There are two beneficiaries. One is the applicants, because their opponent is no longer going to be funded. The other is the community, because the funds will not be misspent.
No, and I accept that as I submit that that interest you have identified, my lord, is not at odds with their public interest at all. The two interests can be perfectly harmonized.
Yes, I know that, but I think it's in those circumstances, and I may have this wrong because I can't remember the authority, there's a case in the Constitutional Court, and I don't know if it wasn't said in the, I forget its name now. Anyway, a case in which I appeared, that there has to be, you have to be the right person to occupy the position of protector of the public interest or the community interest. And as far as I can see, if you've got a personal, if at the same time as you're protecting the public interest, you are advancing a personal interest, you're the wrong person.
But that's what I'm trying to struggle to amplify, which is that the role that they play is not a personal role.
Yes,
They
no,
don't-
I
they don't-
accept that. I
they-
accept all that. I'm not arguing about that. I'm talking about the outcome. They have
Yes.
a beneficial interest in the outcome that they are seeking, which is personal to them. They can fight their case without the seventh respondent being represented by paid lawyers.
No, but Melody, you have to see it from the point of view of this role that they play as not being a role that advances a personal interest. Because once you regard it as a personal interest, you are reducing it to an interest in terms of which their success or loss in the High Court is a personal loss on them.
Let's leave it. I think
Unless
we're
I'm
speaking
misunderstanding
across
you, Melody,
purposes. I
because-
think we should move on.
Because I do want to understand your lordship's concern about this particular aspect. Because the way we present these applicants is to say to your lordship that there are applicants who have a special relationship with the seventh respondent. Seventh respondent now represents everything that the Zulu nation stands for. They are challenging the processes in terms of which seventh respondent occupied the position. That is not a personal interest
No,
issue.
it's not. But the interdicts you're asking for now the outcome of the case is of personal advantage or disadvantage to the applicants because it seeks to cut off money for legal costs.
Yeah.
That may not be their motive. And all I'm suggesting is that there's a case somewhere which says that sort of person is not the right person to represent the community interest.
My lord, I can't really think of a case like that, but I will investigate it in the course of the evening. And if indeed there is a case like that, then of course our argument really is that you have to regard the interest that they're pursuing as not necessarily a personal interest. That they are not pursuing when they are asking for an order that would essentially protect public funds from being spent unlawfully. They are not asking for an order that any member of the public would not ordinarily ask for. The public would be entitled to an order that prevents the board or the premier from dispersing funds, public funds, for the personal benefit of the seventh respondent. It's not just the applicants, it's the public itself would be. And that the applicants have brought the application in circumstances that they have as members of the royal family does not make it less of a public interest issue, because they themselves are members of the public first before they are members of the royal family. All that they've done is to say we're close to the heat, we're close to the institution itself, and we have a special role, which role is not a personal role. It's a role that belongs to the people. We exercise it on behalf of the people. And while we exercise it on behalf of the people, we're entitled not to have the state, which we are challenging, fight with us on behalf of one of the beneficiaries of one of the siblings in the Zulu kingdom who is entitled to be considered for the position of king. So all that they're saying is the state ought not to choose one individual and support that particular individual against a process that they are asking that it be done, which process is involve members of the royal family, particularly them as senior members of the royal family, in the identification and the and subsequent recognition of the king. So the prevention of public funds from being used in order to advance personal interests is what we're against. Because, my lord, you would have known, and it's quite clear, that the decision of the president to recognize the seventh respondent is defended by the state. Because the state has an interest in defending a president's decision, the head of the executive's decision. So that meant that the president then obviously must defend that decision, or the recognition decision. But what is the state interest in defending the personal interests of the seventh respondent in being king? There isn't a state interest.
Hang on. We've got to be very careful if you want to move on to this topic. We have to be very careful.
No,
The president wants his decision to recognize the seventh respondent to be protected and to survive legal proceedings. It's understandable. If the state takes the view that that cannot be done unless he is joined by the seventh respondent in those proceedings, and the seventh respondent says, I don't have any money to join in these proceedings and join you in your opposition to an order setting aside your decision, are you saying the state has no interest in helping the seventh respondent to do just that?
They may have an interest, but it's not a legal interest.
Well,
It's not a legal interest. But let me not be misunderstood. The seventh respondent has every right to defend a decision made in his favor.
he has a right.
By the recognition decision.
He has a right to defend himself against the recognition.
No, he has every right to defend a decision made in his favor by the president.
Yes. Yeah.
He has every right to defend himself. There is no question about it. That's not the issue. The issue is not whether he is standing to be involved in the cases that involve the lawfulness of his.
And would I be correct in saying on these papers, it's common cause between the parties, that the seventh respondent doesn't have the money to fund that himself? He only earns 1.2 million rand a year.
It has not been. There's no, to my recollection of the papers, there's not an allegation made by the seventh respondent that he does not have the funding. In his own affidavit, one can look at it. You can imply it. You can imply that is the case, because the letter has the rights to the chairperson of the Ngwenyama Trust, Ngwenya, and these responses to those shows that he needs help with the financing of his legal costs. Right. But my lord, that is the issue that we carefully have to understand, because should not be heard to be suggesting that the king does not have a right to defend the decision made in his favor. What we are contesting is that the state has no legal basis that they can refer to, and we will listen very carefully from both the Premier and the board to see where they identify the legal basis on which they can set aside public funds in order to fund the defense of the seventh respondent. Bearing in mind, my lord, that when the seventh respondent defends the decision made in his favor, essentially His Majesty is defending a decision, or rather his decision, a decision that is a personal component, personal interest in the position of being king. It's a decision made.
But is the position not that the current board of the Ingonyama Trust takes the view that it has no power to pay the king's costs in this litigation of yours? And it doesn't intend to pay them. Isn't that what their affidavit says?
Yes, it does, but it also says that there is a disbursement policy in terms of which how they wish to assist the king pay for the legal costs. It would be given the 5% of the 5% referred to in the disbursement policy, in order for that to be used to cover the legal costs. And we say that is not the purpose for which that 5% is given to
Well,
the king.
is that 5% lawful at all?
We-
Is
that's
that
also-
disbursement policy lawful? Are you going to accept that proposition?
No, we haven't gone that far, because as I say, I mean, in these proceedings, what we're really looking at, we're also looking into the future. We've marked this aspect of the board, where the board has said there is this disbursement policy. There is this particular decision they've made, which involves the 5% that would be paid. We haven't
Well,
gone
it doesn't really involve the 5%. They've said to the king, according to
That's
their
it,
papers,
yeah, that's
that
for
we're
the-
going to have to pay these installments, and you better get used to the idea that they're going to chew up your 5%. So don't expect any more money from us under that 5% policy.
Yes.
That's what they've said.
No, but that we say with respect, my lord, is a window that shows us a possibility when we get the Rule 53 record, we study the Rule 53 record. It's not just that payment that has been made before. That the position of the board may well have been in the past that this is how they are going to be paying for the king's costs. Also, my lord, because when the board is specifically asked for an undertaking by the attorneys of these applicants that they will not pay these costs, they say nothing.
Yeah, well, that's all right. They've answered now in the affidavit.
Yes, no, but
So let's not go back in history. There's no need for that. It was rude of them, and they should have said something.
yes,
But they've now spilled the beans in their affidavit. They've identified a whole litany of private expenses incurred by the king or the royal family collectively, which have nothing to do with Ingonyama Trust issues and which were paid by the Ingonyama Trust. They've identified it all, and they've said it's all wrong.
yes. We would firstly that concession on its own is very important, because if they had answered the letter we wrote to them, and I understand that you say we mustn't go historical, but if they had written to us and said, we accept that this has happened in the past, we make it clear to you that this would not happen at all in future, we probably wouldn't have this application.
Maybe there was a
We had to
unhappy
bring
timing here. I don't know. I haven't looked at that.
But so with respect, an application has to be brought for them to give us a picture, a window of what their attitude is towards this particular aspect of the case. But
Now,
that would be a position we accept as an lawful position, that they shouldn't pay for personal costs of the seventh respondent. But we've had to extract it through this litigation, that particular concession, that this conduct
Yeah.
would not be consistent.
That-
But there's still an issue relating to we debated this morning, issue relating to how they assumed the payment of these fees, and they paid a certain amount of money and undertook to pay continuously. And I pointed out to your lordship that particular conduct did not accord with any of their powers, because I was able to show your lordship that there is no resolution of the previous board specifically undertaking to make these payments. So when they say they are bound by those undertakings, they are not correct.
are you saying they are dishonest when they say they felt now they were in a pickle? They were in trouble because an undertaking had been made.
No, it's possible that they just misread what the documents that
okay, so they've misread it. That's what they did. Your argument would be they shouldn't have done that.
No. But I'm saying that the legal position they've created as a result of their misreading what Mr. Ngwenya was conveying in those letters is that they've created what we debated this morning to almost amount to an agreement to pay, for which they have now resolved that they want to continue paying that amount because they consider themselves bound by the decision of the previous board. And we know that and maybe when it Rule 42, Rule 53, when it comes up, we'll find a resolution that supports the position they're taking, that they are entitled to assume the responsibility of paying for these on the basis of what the previous board had done.
Yeah. Well, one of the considerations which went through my mind in considering whether I should uphold this objection on urgency or not was this question of the Strauss Daily debt. And it struck me in the light of what you said that perhaps when the papers come through, you will find yourself in a position where it's necessary to draw in Strauss Daily because you're looking for that relief. I thought, yes, well, that's fine, but I can deal with it at the interim relief level this way. And if I decide in your favour to make some sort of interdict affecting their ability, the rights of, affecting the trust and payment of legal fees, I can exclude the Strauss Daily transaction. On the basis that if you want it dealt with separately as a matter of urgency, then you will have to launch another much more simple application than this one, where you ask for an interdict against the implementation of that contract and you join Strauss Daily and the board and get your order that way. But in these papers, in this situation, I can't grant an interdict when Strauss Daily haven't been heard with regard to that particular transaction.
Yes. No, I think
I think that might be the way out.
Yes, I think that you made that very clear earlier on, and I appreciate the fact that you put it as succinctly as you've done in relation to that. But we certainly are focused, as I argued earlier in the morning, we certainly are focused on the authority of the board to do it. And on their own papers, it appears that they have doubts about whether they can do this.
Well, I think they've taken the point they can't.
Yes.
Subject to one thing which we haven't discussed yet, one qualification. I think
on qualification.
One qualification.
Also,
with one qualification, I think I don't need to hear you on that because I think on the papers they've said we accept it's wrong.
Yes.
Yeah. But there is a qualification. Will you tell me when you want to deal with this so-called disbursement policy?
Yes. So they as I understood the disbursement, the arguments around that aspect, that qualification, Lord, is that they want to pay in accordance with the disbursement policy. They want to be allowed to refuse to pay any of the personal issues that involve the seventh respondent unless they are covered under the disbursement policy. We've looked at it, yes, and in Part B we are going to deal with it with that matter in a bit more detail. But what is very clear to us is that when they deal with the issue of this 5%, it appears to us that they are finding a way out of paying for the seventh respondent via that disbursement policy in relation to the 5%. They are saying, well, he is entitled to this 5% in terms of the disbursement policy. Okay. I'm not sure.
And 10% to Nkosi is the same problem.
Yes. So I'm saying that if the idea of the board is to use the disbursement policy in order to cover the legal costs, that would itself be unlawful. And so the reference to the disbursement policy in clause 5, and the 5% is what I recall as the exception that they seek to make, which is that they should be allowed to pay in terms of that policy. And in terms of that policy, the reference is the 5%, which they think they can give to the king to pay for the legal costs. and we say that that would not be appropriate to do. In relation to the Premier, you would have seen firstly that the Premier abides. They filed an explanatory affidavit in which they explain how this whole issue of meeting the legal costs is dealt with. But what is not clear to us, and what is not clear on the basis of what they say, is that they do not identify a specific power that the Premier has in order to pay for the legal fees of the seventh respondent.
Well,
We know that they've set aside
sorry,
30 million.
I just want to find that affidavit.
That affidavit is on page
Starts at 471, is that the one?
471, yes, that's correct. And I'm sure my learned friend, if given an opportunity, will take your lordship through the affidavit. But what is very clear here is that they themselves do not contend that there is a legal basis on which to pay the legal fees. They refer to the KwaZulu-Natal Zulu Royal House Trust. We have no issues with that trust. No issues whatsoever, because we accept that there is money allocated that is for that particular trust that looks after the well-being of the royal family, including the king. We don't have an issue with it. What we say is that there is nothing in law that allows the Premier, and nothing that we've been referred to, that allows the Premier to put a budget item of legal fees in relation to the...
But where is it, the evidence that he's doing that? That's where I got lost.
Oh, no, sorry, my lord. If we go to the page 482, and you'll see there's vote 1 there. There's also vote 2 somewhere, I think.
Vote 1, right?
And there it says Office of the Premier, and it says operational budget. It gives a figure, then it says remuneration of the Premier, and it
So
goes on.
wait, what page are you on?
It's 482. It's annexure A. And it's got a vote 1.
482 starts with overview.
But Lord, I have it as it starts with it is Office of the Premier.
Yeah.
And you'll see, my lord, that there it says estimates of provincial revenue and expenditure.
Where's that?
It's on right on top of the page. If you go to page 483, for example, it's right on top of the page. It says estimates of provincial revenue and expenditure. But where I want your lordship
Sorry,
to go
Mr.
to...
Masuku, can you just hold up your page and point your finger where I find those words?
Okay, so it will be... So this would be page 482,
Yeah.
and it's got vote 1 here.
Yeah.
You've got that, my lord.
Yeah.
And then if you flip over, you'll see here that on every page, I think that's what this is
Oh,
about.
I see. Okay, there's a heading from then onwards. Yes.
Yes, it's
All right.
got this little heading that says estimates of provincial revenue
Yeah.
and expenditure.
Yeah.
Where I wish to refer your lordship to is on page 487.
Okay.
And you'll see under page 487 there is a paragraph that deals with His Majesty the King's activities.
Yeah.
And then it deals with, says, His Majesty, the King's activities include, amongst others, hosting an annual traditional and cultural events to preserve and restore the Zulu culture, as well as hosting and celebrating heritage such as King's coronation. Various events were held, and it goes on. No problem with that, my lord, because that's certainly in order. And then it talks about the Royal Trust, and then the Forensic Investigative Services. There is a page which deals with the King's legal costs, which I thought I'd gotten to. If your lordship bears with me. Let me just
Pardon me, Lord, I think my letter might be referring to page 536. 536.
536. Thank you. Yes, thank you. So in page 536, my lord, you'll see there that there is 30 million was allocated to program 3 towards legal fees incurred by the royal household.
Where do I see this? Where on
It's right at the bottom, the paragraph that where it says other adjustments, and if you look at the middle of the paragraph, it says other adjustments, and the department's budget allocation was increased by a net amount of 50 million received from the provincial cash resources allocated as follows. And then it mentions 30 million was allocated to program 2, and it identifies what that program was. And then it says mitigating this allocation in program 2 is 10 million, and it goes to describe that. And then it says underneath there, 30 million was allocated to program 3 towards legal fees incurred by the royal household. The funds are split between goods and services, 15 million, and cater for His Majesty, the King's legal costs, and transfers and subsidies to department agencies and accounts, 14 million, for transfer to the Royal House ZRHT for the royal family's legal costs. Now, so what the Premier is telling us there is that they have identified legal fees in relation to 7 respondents to be a program under the Premier's budget. And in the 30 million that they've allocated to that program, they've split it between goods and services, which cater for His Majesty the King's legal costs, and transfers and subsidies to the department, which transfers to the royal household. The first point there, my lord, is that we're not sure where the Premier says here is a legal basis on which I can make this a program under the Premier's budget.
But the King can incur costs, legal costs, otherwise than in litigation personal to himself, but in fact to his office, which arise in connection with his office. And those must be within the budget that the Premier must supply, because he's got to do these things. He's got to look after the royal household. So we would accept that the legal costs are legal costs incurred in pursuance of the royal
the Zulu Royal Household Trust issues, then it's fine. But what we're still trying to figure out is whether these legal costs that are referred to here are legal costs that relate to the seventh respondent's litigation in the cases that were involved in.
Yeah, well,
And we would say that if that amount relates to to this litigation, and of course it's got nothing to do with the Zulu Royal Household Trust. It is an issue that would fall outside the Royal Trust. It's really for the King's own interests, and there is no legal basis that we could find in terms of which the Premier would be entitled to cover the legal costs of the seventh respondent if these legal costs referred to here relate to the legal costs that we are concerned about, which relates to the litigation involving the kingship and which primarily relate to the kingship itself. So that would be, and we would, I mean, obviously we are interested in hearing from the Premier where the legal authority, if this 30 million relates to, or this 15 million relates to the legal cost which we are concerned about, where that in fact comes from. Because you would have seen in our founding affidavit, my Lord, that what we have is a situation where we raise the fact that the Premier, can I just, if your Lordship bears with me. I'm just trying to find the paragraph where we deal with the Premier's undertaking to pay for these legal costs, if clarity on the items that are on the invoices is obtained. I think we deal with it somewhere in our affidavit. My juniors will help me out to locate exactly where we deal with that. But all that we say at this stage, with respect, my Lord, is that if the 14 million that is referred to in the paragraph that I referred to in page 536 is referring to this litigation involving the identification dispute, then we can't find that to be within the remit of the Premier to have that covered by her office in legal costs.
in your founding papers, didn't you make some statement about, or put up some evidence? I'm sorry, I'm getting a bit lost now in my own mind. About, was it the Premier undertaking to meet these costs of the seventh respondent, funded by the national government or something like that? Or have I misremembered?
Yes, I do. I do remember. That's what I was trying to get to. But being in the afternoon, that it is, my mind is not working as well as it should work. That's why I always like arguing in the morning, my Lord. These late hours are very dreadful.
You can't take up too much of the morning. We've got other people to listen to.
Oh, I shouldn't take the whole time.
No. I say you can't take up too much of the morning tomorrow because
Yes.
we have other people to listen to.
Thank you. I think we make the point, my lord, which is that the Premier has not even in her own affidavit showed us. Oh yeah, thank you. Right. We refer to it's page 867.
867.
The annexure in page 867. In the affidavit. We refer that annexure. It's a newspaper report, yes.
There's another one that should have been struck out.
It could be struck out, but I'm trying to find out how we supported that particular in our affidavit. If it comes, it doesn't come from our affidavit. Our replying affidavit is 44. So, my lord, in paragraph 44.3, page 827, starting at paragraph, in fact, starting at paragraph 43, we say, despite the averments which have been placed on oath by the Premier's office, the multiple media reports evidence that the Premier's office has been allocating funds and continues to allocate funds for the personal interest of 7 respondents. By way of example, I referred the court to the following. On the 7th of March 2024, this relating to 2027, 7th of March 2024, it was reported that the Office of the Premier will be paying 7 respondents legal fees to the amount of 8.5 million. And then we attach the annexures XS7. And on 10 March 2027, the 7th respondent made a public statement to Amakosi. We attach it, and that statement says the Premier's office is controlling the the article was the 7th respondent complaining that the Premier's office is controlling the 7th respondent and would soon venture into his other affairs and tell him when to make.
I can read it.
You can read it, madam. Thank you. And so then of course the Premier's office manages the King's Diary and all that. But in paragraph 44.3 it says on the 8th of March the Premier issued a public statement where she purported to clarify the position and stated the following. And she says here are the refutable facts. On 6 October 2023, the Office of the Premier received correspondence and various tax invoices from the attorneys representing His Majesty King Misuzulu for fees and costs incurred in a variety of litigation and other matters His Majesty is involved in. And then paragraph C, as a reasonable government that practices prudent financial controls and spending of public funds, the Office of the Premier scrutinized the invoices accordingly, which at face value appeared to be substantially above generally accepted attorney and on-client costs. On 16 January 2024, the State Law Advisor addressed correspondence to the attorneys representing His Majesty, expressly stating that the provincial government is unable to consider payment of any invoices for services rendered unless the services allegedly rendered are described in detail with the appropriate detailed documentation in support of any disbursements that are being claimed. And then the correspondent explicitly stated that invoices that were attached to the so-called letter of demand provided no specificity whatsoever, and the attorneys were requested to submit detailed and comprehensive invoices specifying the various dates on which services were allegedly rendered, the nature of the service, specific matter that the service is related to, detailed fee notes of all council fees, as well as supporting documentation for any other disbursements claimed. The Office of the Premier was clear that upon receipt of the detailed invoices, the said invoices would be further scrutinized to ensure that they complied with standards set out by the Legal Practice Council, whether the invoices would be submitted to the accounting officer for consideration of payment. And then it concludes by saying it is therefore regrettable that an assumption that has been created that the Office of the Premier is withholding, refusing, or reneging on government's undertaking to cover as much as legal fees. Of course, that assumes that the Premier believes that there is a legal obligation somewhere for these legal fees to be covered by her. And I accept readily what you said earlier on.
Not a legal obligation, you mean a legal power.